This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an unsubstantiated legal conclusion defeats a bad faith claim, and why when common law bad faith claims fail, so do statutory bad faith claims. In Texas, in a case called Cowboy Christian Missions versus Church Mutual Insurance Company, the United States District Court for the Northern District of Texas on March 7, 2025, dealt with a bad faith claim that was dismissed before trial. Defendant Church Mutual Insurance Company moved the court for partial summary judgment to eliminate the charges that they had violated the tort of bad faith. Plaintiff's building complex sustained damage as a result of an EF3 tornado, the loss event. At the time of the loss event, the property was covered under an insurance policy issued by Defendant Church Mutual. The policy provided coverage for damages caused by the loss event, subject to the terms and conditions of the policy. Plaintiff submitted a claim for coverage under the policy for damages allegedly sustained as a result of the loss event. Within 2 days of the loss event, defendant conducted its initial inspection of the property, which included one defendant's adjuster, Ben Hodges, 2, a third-party engineer, Travis Ebisch of Nelson Forensics, LLC, and 3, a building consultant, Siaosi of Cavalry Construction. Based on an estimate produced by these individuals, defendant issued payments for coverage of the claim in the amounts of $391,535.53. Defendant refused to issue additional payments and or losses that plaintiff believes were covered under the policy. Among these are relocation costs that plaintiff allegedly incurred while repairs were being conducted on the property and other non-salvageable items damaged during the loss event. Nearly 1 year after the loss event, plaintiff sent defendant a demand letter requesting $1,626,859.31, which Church Mutual refused. Plaintiff sued, seeking breach of contract damages and extra contractual claims for alleged violations of the Texas Insurance Code, the Texas Deceptive Trade Practices Act, fraudulent misrepresentations, and breach of the common law duty of good faith and fair dealing. The court noted the trial is currently scheduled on the court's docket beginning March 24, 2025, just 7 or 8 days from now. Defendant contended that plaintiff failed to show that defendant acted in bad faith during its processing of plaintiff's insurance claim. Defendant argued that the evidence reflects only a bona fide coverage dispute, which necessarily bars the extra contractual claims that involve elements of bad faith, malice, or similar ill intent. The court agreed. Insurance companies have a duty to deal fairly and in good faith with an insured in the processing of claims. This means that as long as the insurer has a reasonable basis to deny or delay payment of a claim, even if that basis is eventually determined by the fact finder to be erroneous, the insurer is not liable for the tort of bad faith. Plaintiff cited to no legal authority or industry standard that suggested who is responsible for investigating new evidence or why. Once counsel and third-party experts are involved, they cannot fulfill this duty. Defendant argued that it did not need to adjust its payment for extra expense because plaintiff did not meet its burden of showing that its relocation expenses were necessary. Under Texas law, it is the policyholder's burden to demonstrate that a claim is covered by and under the policy, as it is in almost every state. Plaintiff did not attempt to list its relocation expenses, so the court could not determine which expenses were necessary. Instead, plaintiff referred generally to American Express charges and an invoice from M&M Construction that plaintiff submitted to defendant, which plaintiff's representative, Court Weldon, was asked about in his deposition. Mr. Weldon testified that these were expenses incurred when Cowboy Christian had to relocate to another building to resume operations, and absent an itemized list and specific support for each item, plaintiff's contention that it incurred extra expenses is and must be considered an unsubstantiated legal conclusion, not evidence. To the extent that plaintiff argued that Cavalry conducted an inventory of all non-salvable items and defendant never produced the inventory, the defendant should produce that inventory if it was requested. The court granted defendant's motion with respect to plaintiff's claim for common law breach of duty of good faith and fair dealing, because there was a reasonable, fairly debatable dispute between the insured and the insurer. Texas courts also have recognized the close relationship between common law bad faith claims and the statutory bad faith claims found in the Texas Insurance Code and the TPA, because the statutory and common law standards are now the same. A finding that there is no common law violation as a matter of law also eliminates the statutory claims alleged by the plaintiff in this case. Defendant's amended motion for summary judgment was granted, and plaintiff's statutory claims under the Texas Insurance Code and the DTPA, and plaintiff's common law claim for breach of duty of good faith and fair dealing were dismissed with prejudice. The remaining claims for trial are breach of contract and fraudulent misrepresentations. In my opinion, as was the opinion of the court, refusing to pay a claim presented by the insured is not evidence of the tort of bad faith. Although Cowboy Christian was upset and didn't receive the money it wanted, that is not evidence of bad faith. It's just a dispute over numbers. The trial will go forward, and Cowboy Christian will present evidence to the court of the amount it believes is covered by the policy to indemnify it for its losses, and will not receive a bonus of exemplary or punitive damages. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.